Imagine a situation where you believe you are acting within your rights, only to discover you are unknowingly committing a serious federal crime. For many people with past criminal records, this can be the reality when it comes to firearm possession. So, which criminal offenses prohibit firearm possession? Broadly speaking, federal law makes it illegal for individuals convicted of a felony or a misdemeanor crime of domestic violence to possess firearms or ammunition. This prohibition also extends to several other categories of individuals, not just those with felony records. The core of these prohibitions comes from federal statutes, primarily the Gun Control Act of 1968 and later amendments, like the Lautenberg Amendment. A felony conviction, defined as a crime punishable by imprisonment for more than 1 year, is a major disqualifier across the board. This includes a vast array of offenses, from serious violent crimes to certain white-collar offenses, as long as they meet that imprisonment threshold. Beyond felonies, the Lautenberg Amendment specifically targets misdemeanor crimes of domestic violence. This means even if a domestic assault or battery offense is considered a misdemeanor under state law, a conviction can still permanently revoke your federal right to own a firearm. Other federal prohibitions apply to individuals subject to certain restraining orders, those adjudicated as mentally defective or committed to a mental institution, unlawful users of or addicted to any controlled substance, and those dishonorably discharged from the armed forces. It is important to remember that these are federal laws, and individual states can have their own additional prohibitions, which might be even stricter. Given the complexity, how can you determine if you are legally prohibited from possessing a firearm? The most crucial step is to consult with a qualified attorney specializing in firearm law or criminal defense. They can review your complete criminal record and advise you on your specific eligibility under both federal and state laws. Simply having a record does not always mean you are prohibited, but understanding the nuances of your particular conviction and its legal classification is essential. Do not make assumptions, as the penalties for unlawful possession can be severe. An often overlooked aspect is what is known as relief from disabilities. While federal law has a very narrow path for restoring firearm rights, many states offer their own processes. This might involve expungement, a pardon, or a specific court order to restore civil rights, which could include the right to bear arms. However, even if a state restores your rights, the federal prohibition still applies unless the state relief specifically and completely removes the underlying conviction, or a very rare federal restoration is granted. This is why understanding both federal and state interactions is key. Navigating firearm possession laws with a past criminal record requires careful attention to detail and expert legal guidance. By understanding the specific criminal offenses that lead to federal prohibition and how state laws interact, you empower yourself to make informed decisions. This proactive approach helps you avoid severe legal repercussions and ensures you fully understand your rights and responsibilities concerning firearms.